Well, hello, I'm Steve Carlson. I'm the one who made this rap video. It's called Fight Like a Girl, Can't You Feel the Rage? Now, this rap video is about the Breast and Cervical Cancer Prevention and Treatment Act passed by Congress in 2000. In Minnesota, it is called Medical Assistance for Breast and Cervical Cancer. And it's based on a screening program, which in Minnesota is called SAGE. And this is about a case where the Attorney General and the Commissioner and the Governor, Mark Dayton, but also Emily Piper and the Governor's former assistant, Tina Smith, who's now in the Senate replacing Al Franken, have taken away Medicaid benefits from women in the program while they're still in their cancer treatment. This is a complete violation of that federal law. It's also a complete violation of the United States Constitution, and for that matter, the Minnesota Constitution. So what I'm going to do in this video is to read to you from the findings of fact that are proposed to a Minnesota state court that is currently reviewing this. They've asked for this to be submitted, and here it is. Proposed findings of fact. This case involves an MABC recipient and her husband Stephen, who is me, who has acted as her representative at all relevant times during her MABC program. This started in 2013, and does so in this judicial review proceeding, and who since July 2016, just after my 65th birthday, has been assessed a spend down to help pay for her MABC breast cancer treatment. Ramsey County Community Human Services, the county who administers her MABC in Ramsey County, where she and I live. The county being represented here by Director Tina Curry, Financial Lead Worker Ebony Phillips, and Caseworker Terrell Nelson, who has been involved in her case since at least August 2014 to the present. And the Minnesota Department of Human Services being represented here by Commissioner Emily J. Piper. The present appeal is limited in scope to the final decision and facts known to the Commissioner at the time, June 8, 2017. But that decision was adopted as DHS docket number 185231. And by the way, that decision reversed all of the terrible, atrocious actions by Ramsey County. But Ramsey County has simply known that it wouldn't be enforced, so they went ahead and cut it off. And that's more than a year ago. So this is really a terrible situation. And I guess hundreds, I'm told, hundreds of women in Minnesota alone have been thrown off their breast cancer treatment. And if you expand that to the whole nation, I certainly hope this is not happening. But that's thousands of lives that are at risk, and a large percentage will have been lost because they're playing with the money that Congress that they promised for this program. And I believe it has been appropriated. There's been no indication they haven't appropriated the money. But this state is stealing it. Now, there's no dispute that the appellant has been screened and found to be with breast cancer beginning in October 2013 by the NBCCEDP, that's the National Breast and Cervical Cancer Early Detection Program, screening program, and it's called SAGE in Minnesota. And that she has been prescribed hormone therapy as part of her life-saving cancer treatment funded by Congress and by the Minnesota legislature, which is for the purpose of the mortality reduction legislation passed by Congress under BCCPTA, the Breast and Cervical Cancer Prevention and Treatment Act, passed in 2000, passed as MABC, or Medical Assistance Breast and Cervical Cancer, in 2001 by Minnesota. There is no dispute that the treatment is intended to proceed through 2019. Her oncologist gave appellants this information in a consultation. When it will be about 5 years of hormone therapy on top of surgery in 2013 and radiation in 2014. So here the hormone therapy replaced chemotherapy. That was a decision that was made by the oncologist. Now all the surgery, radiation and hormone therapy and consultations with medical providers for cancer treatment have been paid for by MABC in Ramsey County through October 2016. It is unclear if these payments were made beginning in July 2016 when a spend down was assessed on appellants by the county and no spend down was ever paid, and appellants have never paid any spend down. That is to say, appellants have never paid $433 or more in medical bills in a month and then reported those bills to the county and requested payment for medical bills in excess of $433 or more for that month. No notice or other contact with the recipient by the county in assessing this spend down in July 2016 ever occurred. The county respondents have only admitted that they failed to give adequate notice to Victoria, to the appellant, that she would have to be paying these spend downs and collect and submit bills to prove to the county that she qualified for this benefit of being assessed a spend down for all medical assistance payments. Now all of this was covered by the county and the state and the federal government because of this beneficent act by the Congress. But they cut that off, and that's what this case is about. So, but the Human Services judge in this decision number 185231 found inadequate notice from the county that's a procedural due process violation because appellant was assessed a spend down while she was clearly still eligible for MABC, which requires no spend down. And that on this basis and without adequate notice, said the Human Services judge, and her findings were adopted by the commissioner, but just not enforced. And then she was deprived of both MABC and MA medical assistance with a spend down. They even took the medical assistance with a spend down away while she was still eligible for the breast cancer medical assistance. Now, and this is how that happened. It's really strange. Beginning October 5th, 2016, which we call the original NOA, it is undisputed that with the exceptions noted herein, Ramsey County informed Victoria that she had been subjected to MA with a spend down since July 2016, more than 4 months prior to her 65th birthday on November 11th, 2016. Although, as Judge Longfellow found, affirmed by the Commissioner June 8th, 2017, there is no dispute. She remained eligible for MABC with no spend down through at least November 11th, 2016. Husband Stephen, since my 65th birthday, was June 28th, 2016. And this coincides with the time spend downs under medical assistance for the elderly, MAEP, began to be assessed. Now, she was further informed that based on the county's finding that she failed to pay any spend down, she was being removed from all medical assistance, which would include the breast cancer medical assistance, effective November 1st, 2016, 10 days before her 65th birthday. And on October 26th, 2016, and after the original NOA from the county had been timely appealed, with a timely request to keep the MABC benefits in place on appeal, and after there had been discussions by me with the county financial lead worker at the time, Delphina Reynolds, the county sent another NOA saying that she would lose her MABC benefits, which had already been noticed to be terminated since all medical assistance had been lost by her being assessed a spend down since July 2016. Now here's the thing that we appealed that as well, and the MABC has no spend down. So this was appealed with a timely request to keep the benefits in place. On appeal, it was made to the county and the commissioner through appeal. But according to county testimony, that's from Ebony Phillips, the MABC was never restored. Only MA with a spend down was restored, which resulted in no payments for appellant's medical care since she and her husband never paid a spend down. And actually, we couldn't pay a spend down in any month, let alone every month. Now, appellants informed the county they believe that MABC and BCCPTA, and being screened under SAGE and found to have breast cancer, entitle appellant to have her medical care paid through a categorical Medicaid benefit during the time she has been determined under SAGE and MABC to be needing cancer treatment. And on that basis, we appealed the county's determination to terminate her MABC and deprive her of its benefits. Appellants have never wanted the MA with a spend down and have filed no paperwork to apply for that, and were found by Judge Longfellow to make a compelling case that we could not pay for the other necessities of life and also pay that spend down. So that benefit provided no medical payments for appellant's cancer care, which we believe have been funded by Congress. Now, although at the Longfellow hearing, Judge Longfellow's hearing, Ebony Phillips was not forthcoming about when we appealed the October 5th, 2016 notice and sought to keep the MABC benefits in place. And that's important because if you do that, then they're supposed to stay in place on appeal, and the Supreme Court has said you have to allow people to do that. Actually, I don't think you should have to do it within 10 days, but we did. And Phillips lied about it, basically. She said, well, I don't know if they applied for a spend down, applied for to keep the benefits in place or not. Well, they didn't put that in the records that they sent to the appeal. That's how these people operate. That's really sad. Now, since the county failed to include a copy of that in the appeal and request for continued benefits on appeal, it was a question there, but Judge Longfellow did locate the appeal and request for continuing benefits during this appeal. And just after that, Ebony Phillips replies, actually, I just saw that now. This is the kind of people you're playing with. If she was on the phone, she wouldn't get in the hearing like the law requires. Now, at the same hearing, Longfellow asked Phillips why the county had not made any medical payments on appeal, although timely requested. And Phillips answered she did not know why. And you can see that in the transcript. She speculated maybe it was related to the failure of appellants to appear at a hearing on December 14th, 2016, or it could have been the county's computer system. She said she would have to investigate what her predecessor, Delphina Reynolds, had done. Now, after appealing the October 26th NOA as well, appellants received another NOA on November 14th, 2016, after Victoria's 65th birthday, informing them that because she had appealed the NOA depriving her of her breast cancer benefits, they would be restored on appeal, but only through December 1st. So they were cut off on December 1st by that notice of appeal and had nothing to do with any hearing on December 14th. So we also appealed that because the restoration was only through December 1st, 2016. Please pardon my noisy parrot. And not for the pendency of the appeal as the law requires. The MABC benefits did stop December 1st, and they had already stopped, but had been started up for just those 2 weeks. Not because we didn't appear for a December 14th hearing, which, by the way, we had not received any of that information, even though we called the county to please send it. They deliberately sent it to the wrong address because they sent something to the right address that wasn't any notice of that appeal hearing. So, although appellants requested an in-person hearing before the Human Services judge in our appeal from the October 5th NOA, this original NOA, and I've got a footnote here I might want to read. Now, I want to explain that you hear all these appeals. Although the appeal was taken from the October 5th action, as the county continued to change the status quo with a number of new NOAs, notices of appeal, or notices of action, and notifications after that, we also appealed all or virtually all of those as well within 10 days with a request that benefits be kept in place. And being duly advised, we were that if we lost the appeal, we might have to pay back those benefits after would have been that were received. So the thing is that she's supposed to have it all paid for, but here we're being threatened with overpayments as we basically try to navigate our way through this very difficult problem. Now, I want to go back to 2014 when this all started. Because beginning in August 2014, respondent Terrell Nelson, the caseworker, began to deprive the appellant of her MABC benefits, terminating her multiple times because she was required, it was said, to go to the Social Security office and try to qualify for Medicare. And this was at age 63. And disability under Medicare at age 64. We complied with these demands in order to keep the breast cancer treatment coverage going. But she was also temporarily deprived of MAB benefit payments to providers in about August of 2014. So you can see this is a gross case of abuse. And I put in a footnote reminding them that since December 1st we haven't got any of those benefits, and in fact the record we submitted shows the last payment was on November 17th of 2016, and even though they send all kind of forms, they all say, yeah, here's the medical services, and no, we didn't pay a thing on it. And that's on the record before the court and was before the HSJ, but it was so confusing, I don't think she quite got all of that, because she was trying to figure out what did these people do, because they don't know. So how's the judge supposed to know? They don't tell us because nobody understands what they're doing. Okay. Now, although we raised this matter of the events in 2014 and 2015 in the Longfellow hearing, it has not been pursued by the commissioner. But this court, we're proposing and put in its findings of fact, takes note of it based on the record of the case and based on testimony and argument from the representative Stephen at the March 2nd, 2018 hearing. We had that hearing with the judge on 2018 before this court because it is material to the administration of the appellant's MABC rights and entitlements by Ramsey County and the commissioner. There is no dispute. Appellants also timely appealed all of these 2014 and 2015 actions and did ask that the MABC benefits remain in place within 10 days of the notices. And by the way, if we had not done that, all of the breast cancer treatment coverage would have been lost in 2014 and again in 2015 because they use these procedural things to go in and weed people out, not just at 65, but anytime they want, because they want that money. And it's really, really a terrible thing. But let me continue on. Now, the sole exception to filing these notices is August 2014, when we received no notice, and the MABC benefits were restored by a co-worker of Terrell Nelson's while she was on vacation. We're sitting here suffering without benefits. She's taking vacation on the taxpayers' money because she's got this kind of job. These kind of people, I just don't know. Now, since being, while there is a dispute because now the county and commissioner claim they did maintain MABC benefits in place for appellant through April of 2017. At the commissioner's hearing with Judge Longfellow, Phillips testified that in November 2016 they restored MA with a spend down and not MABC. And with the 2-week exception from November 14th on, she has never had MABC program during the relevant period of this appeal from the commissioner's final decision, which was up to June 8th. So it's just through June 8th, which is what the commissioner decision is about. They never paid these, and yet they lie now on the record saying to the Attorney General, and she accepts this, oh yeah, they did pay it. It's just that there's no payments that were made. Now, since being notified in October 2016 that her MABC had already been withdrawn and replaced with MA with a spend down, appellants really have repeatedly asked the county and the commissioner. Appeals to the county were also and were sent to the commissioner's appeals office to restore the MABC during that funding, and this court has from the beginning been asked to restore that funding. So we've asked this Ramsey County court since at least since August, I think it was before that. Please restore this funding. This court is sitting there knowing that it's been cut off, we're not getting it, but I don't know, she figures maybe we don't deserve it, so she has done nothing about our appeal to get that fixed, even though the HSJ, the Human Services judge, did order it. But this judge is so unfamiliar, uncaring about it, she is ordering nothing of the sort, and of course we're asking her to do that. Now the absence of that funding creates medical bills piling up unpaid, avoidance of medical treatment by the recipient who fears bad credit and collections, and grave irreparable injury through increased risk of relapse and threats to the success of the cancer treatment itself. Now, since the purpose of the BCCPCA is to provide funding for cancer treatment for those individuals positively screened under the federal act and state screening programs, and determination that treatment is needed, using Medicaid as a vehicle for a categorical Medicaid benefit, this is different than needs-based benefit. So you can see already the competition for funding at every level. It's a great idea, provide the funding, but then you have to fight with the welfare people like from day one to actually get that funding because they steal it, all right? I'm saying they steal it, and I think it's very clear now they take it. And they try to find multiple ways to take it. And these are people that are cancer patients. Imagine somebody that didn't, like I know, to go and appeal that immediately so you don't lose it. And what is happening to these women? It's really a nightmare. All right, so since that is true, the appellants now have made, we believe, a compelling case that we will win on the merits. And when that promised entitlement was repeatedly and for extended periods deprived without required procedural due process. They just do it on a whim. Now, as part of the categorical benefit, the commissioner is required to pay for a template of standard Medicaid services for all cancer patients, such as the commissioner paid for from 2013 to October 2016. There were some payments made for medical costs incurred by Victoria, but only through November 17, 2016. Now, these medical payments are part of a template, but they also play a critical role in maintaining the optimal lifestyle and psychosocial conditions for successful outcomes. And I've set this out in an affidavit to the court. After the hormone therapy, which is what that's doing, in other words, the relapse after that hormone therapy ends, because right now it's killing cancerous and precancerous cells and preventing their appearance. And after it's withdrawn, sometime in 2019. That's the risk that we're trying to deal with through actually paying these funds so she can actually get this medical treatment, which is required by Congress, but disobeyed by this state and this county. This is a timely appeal from a contested case pursuant to Minnesota Statutes 256.045 Subdivision 7, Judicial Review. The Administrative Procedure Act, Minnesota Statutes 14.63 to 69, governs the conduct and authority of this proceeding. The record shows no payments for medical care by the county from November 17, 2016 through June 8, 2016, when the Commissioner adopted her final decision in DHS docket number 185231. In October of 2013, recipient and appellant at age 62 was unfortunately diagnosed with the breast cancer. Fortunately, she had responded to a mailing from Minnesota's Low-Income Mortality Prevention Program, SAGE, which is Minnesota's version of the National Breast and Cervical Cancer Early Detection Program. And her husband, me, appellant Stephen, had learned about that program as I worked at the Minnesota Regional Office in Eagan, Minnesota, of the American Cancer Society, and researched the resource and put it on cancer.org. Many of you may have heard of that very valuable resource for anybody affected by cancer, not just breast cancer, but all kinds of cancer. And I campaigned, in fact, for the U.S. House of Representatives on the issue of attacking killer diseases and eliminating health disparities beginning in 2010. Now remember, my family was not affected by this until 2013. So this was purely me looking at resources which will save the lives of women in Minnesota. And I campaigned on this when Obamacare came up. I said, well, what we should be doing is attacking these killer diseases and eliminating health disparities that would save so many lives. And so I raised this issue in debates for the office of the U.S. House with Representative Betty McCollum and various Republicans, and again in 2014 when I was selected as the nominee by the Independence Party for the U.S. Senate against Al Franken. Now during that race, the appellants we were already fighting the breast cancer. While I was fighting Al Franken, we were fighting breast cancer with the help of medical assistance breast and cervical cancer, which is Minnesota's, again, version of the Breast and Cervical Cancer Treatment, Prevention and Treatment Act. Now, because we had lost our Minnesota Care, you probably heard of this wonderful Minnesota Care, well, we lost it. Despite keeping our premiums paid, so when I saw the SAGE, when we saw SAGE, we understood it could give her the treatment if she was actually found to have breast cancer, which we kind of suspected at the time. But that program saved her life. On October 15th, however, 2016, we were very surprised to learn she was being purged from the MABC benefits. They were not resumed, except, they weren't. There was a 2-week period where they put them back because of our appeal, and then for some reason they just dropped them again, even though the appeal is still there. And they were not resumed. And on June 8th, 2017, actually, this is wrong, it says 2016, but on June 8th, 2017, Commissioner Piper adopted Judge Longfellow's recommendations to order restoration of the benefit payments immediately and to reverse all the actions, these terrible actions by Ramsey County after October 5th, 2016. Ebony Phillips testified in the hearing she did not know why Ramsey County did the things they did to appellants. Of course, I was running for office, and this is really when this stuff started, but we still need to get that out in the open. Now, in August 2014, again beginning October 5th, 2016 and before, again on December 1st, 2016 as I've set out, and in April 2017 with Ebony Phillips conducting just the craziest action to keep these things from being paid. Went to extraordinary lengths to make sure that my wife did not get her cancer treatment paid for as the law required. I mean, these people are corrupt. So this was all done. All of these deprivations are without the procedural due process required by the 14th Amendment of the United States Constitution and the U.S. Supreme Court in Goldberg versus Kelly from 1970. So she's been deprived of her treatment benefit, payment benefits under Medicaid in violation of all the applicable governing MA policy, medical assistance policy, a federal law. We're actually talking about the Medicaid Act policy as well, the federal law, and statutory and constitutional requirements. These two other incidents in 2014 and 2015 also produced grounds for removing her that are not valid, imposing unlawful requirements on her to get her Medicare or disability, which you can't get before you're 65, in order to make her ineligible for this medical assistance, breast and cervical cancer through the force of state bureaucrats. Now, there needs to be a fair hearing that addresses all of these, and that hearing has not happened. Neither the original NOA notice of action, which we appealed, nor any combination of subsequent NOAs has yet produced a fair hearing on exactly what the county is trying to do to appellant and what their legal basis is, so that appellants can, under the procedural protections required by Minnesota statute, even receiving the notice, make our appeal with benefits in place on appeal, receive the state agency's summary or the county agency's appeal summary, and have them appear at that hearing with us so we can defend against whatever proposed actions would strip the recipient of a categorical eligibility under Medicaid to have her treatment for cancer paid for. Now, as she testified in this court's March 2nd, 2018 hearing, she wants the remaining 2 years of the MABC eligibility through the time her treatment is scheduled to end in about another year. Now, far more than a full year has been lost without those payments being made, as Ramsey County failed and refused to maintain the benefits in place on appeal as timely asked by us. Now, respondent commissioner, through Larry Swanson, Minnesota Attorney General, has submitted as exhibits the congressional record from 2000 of the House of Representatives passage of the BCCPTA bill and of the U.S. Senate in adopting its version, and the reconciliation bill agreed to by the U.S. House in 2000, which was eventually enacted by President Bill Clinton. The bipartisan support for this bill is shown by the fact that President George W. Bush, while governor of the state of Texas, endorsed the bill, as did many governors. The role of governors like Mark Dayton or his assistant sidekick Tina Smith is critical, as the state legislatures in passing this statutes conforming to and implementing and adopting the option, it's an option of the BCCPTA, they have to, the governor and the state have to be behind this bill and make it work. Now, while the commissioner purports to find in the congressional record, which I've read, support for her position that women already in the MABC program, after its effective act, and eligible, could be reclassified as ineligible merely because they successfully survive an age in treatment until they attain 65. And this creates a patchwork of eligibility statuses that constantly change based on the ages, treatment for which they are eligible is commenced, and their lengths of treatment. But the court finds no support. That's what we are proposing she write. There's no support for that in the congressional record. Now, appellant testified to Judge Longfellow that knowing or fearing she had no coverage beginning December 2016, she avoided making medical appointments because she couldn't pay the bills and could get bad credit and have her part-time wages garnished. The record shows that because Ramsey County treated her as if she had failed to meet spend-down requirements for MAEP, the elderly program, they disenrolled her from all medical assistance, and on November 1st, 2016, enrolled her only for MA with a spend-down. The Minnesota Attorney General's submission on February 21st, 2018, after 2 years, they finally come up with this stuff, is filed by the Assistant Attorney General Brian O'Neill Terry, is the first real explanation of the legal position of the state and the county on many levels, but most notably on the issue which was not mentioned in the October 5th, 2016 notice of action appealed by appellants, and I got one final footnote here. Appellants formally appealed virtually all of the notices of action which came beginning October 5th, 2016, even one on November 14th, 2016, saying that her NABC benefits would be restored through only December 1st of 2016, apparently because she appealed, apparently this was put in place because we had appealed from the NOA talking about NABC and saying they would terminate it. And this was after they've already took it away. And it did go into effect because it went into effect and it was taken away on December 1st. Now the county has, and by the way, there's no explanation from the county why the benefits were cut off, and the effect of the commissioner's June 8th, 2017 findings was to reverse all the actions of the county and to order them to also restore the MABC benefits immediately. The county has trivialized these orders and have admitted that they refused to follow the earlier instructions they inferred from Judge Longfellow's troubled questions in the administrative hearing. Instructions that they restore the MABC benefits immediately because of the dismissal of the appeal in December 14th, 2016 had been reversed by the Commissioner's Appeals Office. So the cessation on December 1st, 2016 of the benefits restored by the November 14th, 2016 NOA could not have been caused by any purported failure of us to attend the appeal hearing, which was supposedly on December 14th. So why did they cut it off on December 1st? The record indicates that the county failed to mail the appeals summary to appellants or the notice of the hearing, actually, in November 2016. And then another item, which was a spending summary of what they had paid in October, was mailed to their mailbox on that date. This is why the appeal was reinstated by the head of the Commissioner's Appeals Office. Now that's the last footnote, and just to finish this proposed findings of fact for the State District Court in Ramsey County, and this has been mailed in on Friday, and that is the issue that the state believes it may automatically and without a hearing simply transition all MABC recipients to MA with a spend down for the elderly program, where in many cases they will receive no further medical payments from Medicaid during their remaining cancer treatment. Her oncologist has told us that at least hundreds of women in Minnesota alone are treated this way as they attain age 65. So I'm going to take this out with a repeat of my rap video.
Most of you women are up for re-election in 2018. My message to you is it's time for you to fight like a girl.
For some reason this is kind of unclear.
Justin Timberlake in the background. Fight like a girl makes you feel the rage at age 65 or whatever your age. Progress, a yellow, black cat, or beige. Fight for the right to get on the same page. Breast cancer, corpse, Minnesota sage. These growing forms got a fight to wage. Got her in her face, and we got to engage. Still dozens of women suspect to enrage. The government is serious, it makes you furious. Commissioner's furious, court's not even curious, and they throw Brandon off to the cliff. The government doesn't need to see the justice clear. It's a program for life, it's got a panel of death. You have to make a move just to get the right, so we got the fight. So someone like a Minnesota means to me, well, it's a statement of sweet land of liberty. Well, we put our rights and privileges all down in writing, got the writing, do the saying. So we pass a law to say that women from the proceed. We occupy and want the money to do as they please. They should have used it all again to fight against cancer. Instead they see the chance to play the necromancer. What Minnesota means to me is really chilling. Should be saving lives instead of doing the killing. Sweet man, the liberty, that's what it means to me. I'm ready for fighting. Gonna get excited. Don't want to make trouble, but you know I didn't ask. Competence are critical, I'll take you to test. You're telling me Amy kill the shot. They say she's signing up for new kind of war and women. And older women sticking with camps. They say she doesn't even want to give me a chance to get ill and eat you 55 alive. She just won't let us survive. Can't take the feeling with down in my soul. It came under the sun in the Super Bowl. Not just football, a nation state, American school, a constitution, and the people rule. Granted by God who gave us the tool to make the best law effective to help our cause. So let's do it. Let's move the nation ahead. Let's build the nation that the founders said. Sweet man, the liberty of the Indian state. Wake up, Minnesota, got the freedom word. So let's talk like a girl all around the world. White girl, black girl, red girl, brown girl, medical back girl, moving around. It's time to fight back. It's time to get down, girl. If you're 65 and you're still alive, well, you know that's the plan you were meant to survive. Swats may be culture, combine to be cut. You got to push back, combine to drive. Drive them out of office on election day. Don't let them stay. We're not here to play. They won't get serious. We're going to get serious. No, we don't fight in the court. We don't fight in the cage. We don't fight in the court. We're the battle on the race. Court to happen to abort, but we don't fight space. Those who abort will make the grave. Hey, Attorney General, we'd like half to go federal. But to give you any status, it's to make it automatic, to take a woman's life, to take 65, the purpose of the program is to help her survive. Just like you take a penny from a little ball, you're playing with a woman's life, you think it's your toy, you think it's a game, but you're out to destroy. So fight like a girl, that's a wisdom book. So give it a whirl, and you fight like a girl.
So that is the video, and this is the explanation of what we proposed to the state court at this point. We may have to go further. I'll just stop this right here.